Welcome to our first Venable Nonprofit webinar of 2023. It's good to be back. We always try to pick topics that we think will be of general interest, but we've never had one that's been of such interest as this one. We have about 1,100 people who have registered to participate in this webinar. Our topic today, as you know, is grant agreements, what to include and what to look out for. We want to talk about that from both the donor perspective and the grantee perspective. I'm Bob Waldman at Venable, joined today by my colleague, Nikki Kerman, and thrilled to have as our guest from the Harry and Jeanette Weinberg Foundation, Darius Graham, who's program director there and intimately involved in grant making. What we'll talk about in order is I'll make some introductory comments, and then Nikki will sort of walk us through provisions that would typically or frankly atypically be in a grant agreement and the things to look out for. And then Darius, from his perspective, will talk about some practical experience and things that he's seen in his world. So with that, welcome, and let's get started. So let me start out a little bit at the beginning and talk about what is the purpose of a grant agreement? Why even have a grant agreement? And with some exceptions, and Nikki will talk about that later with respect to what's known as expenditure responsibility. But with some exceptions, the having of a grant agreement is not a legal requirement. There's not an IRS rule. There's not a state rule that says you must have a grant agreement. So given that, why do people have grant agreements? Well, as you all know, a grant agreement typically sets out the terms of the grant, the basic terms. How much is the grant, the timing of the making of the grant, what reporting requirements are required, and frankly, may have some unusual provisions that you want to cover in it. I mean, the basic principle of a grant agreement is to clarify the rights and responsibilities of the parties, of the grantor and the grantee. What do we require of each one? What is each one going to do? What is each one going to be obligated to do? Similarly, one of the values that we have found in our practice in terms of having a grant agreement is to satisfy both your internal and external auditors. Quite commonly, you'll see in your experience that your auditor, again, whether it's internal, external, will say, well, let me see the terms of the grant. I want to make sure you complied with what the grant said. It was supposed to be used this way. I want to make sure you did. So to do that, I need to see what did the grant agreement require. Frankly, you've seen that a lot during COVID, frankly, and particularly with respect to government grants, where you might have gotten grant money that said it has to be used a particular way. It has to be used for COVID-related things. Well, the only way you can tell if you've actually done that is to look at what did the grant agreement require. And finally, again, one purpose of a grant agreement is it has become best practices that if you talk to various grant makers and grantees and they'll say, yeah, that's what we want. We want to have that in our file. We want to know what the grant says. So let me turn to the next slide. Nikki, if you could, is when do you use a grant agreement? So probably the most basic point is there is no one size fits all when you do grant agreements. Sometimes the grant will be as simple as a simple letter that says, hi, here's some money and here's the check, and nothing more than that. Do good things with it. Sometimes it's a very complex agreement. It could be, multiple pages dealing with all kinds of things, intellectual property rights, reporting requirements, all those sort of things. So, and sometimes it'll be, I've seen ones as simple as you get an envelope and there's a check in it. So we'll talk about when does it make sense to have one thing versus another. So what factors, though, would you be thinking about in deciding, do I need a grant agreement? How simple should it be? How complicated should it be? Well, I have to think about the size of the grant. What I might require for a $5,000 grant is going to be very different than what I might require in $1 million grant. In other words, if the grant's quite small, having all kinds of provisions is maybe overkill. What are the purposes of the grant? Is it a grant for a specific program or a specific project versus a general operating grant? If it's going to be for a specific program or project, chances are you're going to have a more detailed agreement outlining the project, how it's supposed to be run, and what you hope to accomplish from it. If it's an operating grant, here's money, just do with it as you please, probably not the need for all the same requirements. What is the grantor's interest in the outcome of the grant? Does the grantor care about what's going to be produced from the grant? Because if that's the case, you're going to have more detailed provisions in the grant agreement. And I've seen ones literally where you'll have one nonprofit making a grant to another, and the grantor might say, if this thing you ultimately produce, this technology you produce, this literary work you produce becomes profitable, I want to share in those profits. So if I care about the outcome of the grant, I want to know how it's going to be used once it's produced. I want to have rights to it once you finish the project. Then you're going to have that spelled out in the grant agreement. It'll be more detailed. Depending on how much the donor cares about what happens to the grant, you may have more extensive reporting requirements in the grant agreement. Sometimes grantors make grants and really don't care. They say, here, I trust you. Here's $5,000 to do good stuff with. I don't really care what you do with it. And you may not have no reporting requirements, but typically you will want to know how the grant turned out, how was it used, and you will have reporting requirements. And if the grant's for an unusual purpose, something atypical, then you're going to want to spell that out in an agreement, and that would lead you to want some sort of detailed grant agreement. So with that background, let me turn now to Nikki to walk you through provisions you would typically find in a grant agreement and what the point of them is and things to look out. So Nikki, let me turn this over to you now, if you don't mind.
Hi, as Bob mentioned, I'm going to walk us through a grant agreement. You don't necessarily have to have a grant agreement, as Bob pointed out, but in a lot of situations, it is ideal to have a grant agreement for all the reasons Bob discussed. The grant agreement provisions I'm going to walk us through include kind of everything in the kitchen sink. So this is going to be the most comprehensive version. And as we go through each provision, I'll talk about which ones you want to include and when. Some provisions will be specifically for expenditure responsibility. Some provisions you'll want to include even the most simple grant agreement. And some provisions will be on a case-by-case basis, depending on the facts involved in your particular grant. So we're going to start off with something simple, the effective date. So you always want to make sure you include an effective date for a couple of reasons. If you're the grantor, it may start the clock on the transfer of funds. And we'll get to that a little bit later when we talk about the grant amount and the payment schedule. If you're the grantee, it may trigger certain obligations, like either benchmarks or reporting, especially if your payment schedule is based on installments. Okay, so the effective date is important. I've seen people, have effective dates that can be effective as of the date of signature. They can be a different, a future date if we're signing it now, but the grant agreement won't become effective until a later date. So you want to make sure that both parties are in agreement and understand what the effective date of the agreement is. So that's an easy one. Next, we're going to talk about the grant amount and the payment schedule. This is important for a number of reasons. Obviously, the grantor wants to make sure that they're committed to the proper amount of money. You want to verify the correct amount and the currency. The currency is important, especially when you're talking about international grant making. If you are a grantor and you're making a grant to an international charity, you want to make sure that you're giving it in the appropriate currency, whether that is dollars for you or if it's pounds for a UK charity, that both parties recognize and agree what the currency for the amount is. Make sure all of your decimal points and commas are in the right place. That's a big mistake if you can sign the grant agreement and the amount is incorrect, right? That's something you don't want to have happen. You also want to make sure, for example, for a grantor, if you are a private foundation and you want this to be a qualifying distribution, when the actual money changes hands is generally when it will be counted for purposes of a qualifying distribution. Typically, if it's distributed before year end. There are some exceptions if it's irrevocably committed, but you want to make sure in terms of the payment schedule that it coincides with when you're able to make those payments, whether that's in X days following the effective date, which is why it's important to make sure the effective date is accurate, or whether it is some sort of installment payment, installment payment schedule based on a number of days or other kind of benchmarks. If payment is going to be made in assets other than cash, for example, marketable securities or even real estate or any other kind of assets, you also mentioned that here as well. If you're the grantee, you want to make sure, when you're getting your money, is it going to be a lump sum payment or is it going to be an installment? And if it's an installment, are those installments tied to any kind of obligations on your behalf? Are you required to submit certain reports prior to getting the next installment payment? Are you required to hit certain benchmarks and demonstrate you've hit certain benchmarks before you get the second installment payment? So that's something important to look out for as the grantee. Okay. Next, we're going to talk about a grant purpose, right? So grant purpose and any required notifications. The purpose of the grant can be as simple as, go and do good things with it for your general charitable purposes. And, the grantor doesn't really have any specific project in mind, can be just general. And in that situation, you can just have a one sentence, for general charitable purposes. You don't even have to have the purposes listed if it's just for whatever the grantee wants to use it for, okay? But if it is an unusual project or something more specific, you want to make sure that that's listed and described in the agreement so that both parties understand exactly what the funds can be used for. You also want to make sure that it's proper purposes, right? They're proper charitable purposes, because if the grant is being used for, something that's non-charitable, or, for example, if you are, as the grantor, are a private foundation, you want to make sure it's not going to convert your grant into a taxable expenditure. If the grantee uses those funds for example, for lobbying or to influence an election or other prohibited purposes, and that can result in taxable expenditures for you as the grantor. As your grantee, you want to make sure the purposes are not too narrowly defined, okay? Because in some situations, it may, the grant group may state if you're not able to use the grant funds for the described purposes, you have to return any unexpended funds. And if the grant purposes are much too narrow and you're unable to use all of the funds for those purposes, you have to, return that amount of money. So make sure that it gives you a lot of latitude and that both parties understand exactly what the money can and cannot be used for. Also, for required notification, this provides additional grant oversight for the grantor. If you are an expenditure responsibility grant, you're a private foundation exercising expenditure responsibility, you want to include this immediate written notification for a lot of different reasons, because you want to have insight as to when the grantee is no longer able to use the certain funds, or if they're using funds for an improper purpose or a purpose that's not been discussed. It may be a purpose you agree with, but you want to know in advance so you can give kind of that advance written approval in each situation. If you're the grantee, on the other hand, you may want to push back on this, especially if the grant is being made for your general charitable purposes. If that's the case and you have wide latitude on how you're using the funds, you don't want to have required notification provisions that require you to notify them every time you use the funds for something different, or if you're unable to use the funds for any purpose. If it's for your general charitable purposes, you want to go ahead and push back on that so that you're not obligated to notify the grantor in those situations. Okay, next we have prohibited uses. This is especially important, again, for expenditure responsibility. And expenditure responsibility, for those of you who are unaware, is when you are a private foundation and you are giving a grant to an organization that is not a domestic charity. Okay, so any organization that is not a domestic public charity, specifically. So a private foundation grant to another private foundation, a grant to a non-charitable organization that may be using it for charitable purposes, a grant to a foreign organization. All of those situations will require you to exercise expenditure responsibility, which has certain specific requirements laid out by the IRS And here, for prohibited uses, this just lays out all of the restrictions on the use of grant funds. Okay, so this kind of goes hand in hand with the purpose of the grant. So you want to make sure they're not using it to carry on propaganda or influence legislation, to influence any kind of public election or voter registration drive, grants to individuals. All of those things are laid out here and highlighted. And that's especially important, for example, if you are giving a grant to a public charity that maybe engages in some level of lobbying or has a 501(h) election, and you as a private foundation, for whatever reason, want to restrict those funds, you want to have that in there as well. But if you're a grantee, and again, you are a public charity engaged in some lobbying, or you have a 501(h) election, and you want the flexibility to use those funds for those purposes that are permitted within your tax exemption, then you want to push back on this. You want to strike this, especially where the grantor is not required to exercise expenditure responsibility with respect to your grant. This can be unduly burdensome or overly restrictive for you. Okay, next we have withholding and repayment. Here, again, this is an expenditure responsibility requirement. You want to make sure that as the grantor, it basically acts as a stick to ensure enforcement of the other provisions in the agreement, okay? And it lays out all the various ways that you as the grantor can require the grantee to either return the funds, or the situations in which you are allowed to discontinue or modify or withhold payments if the grantee does not comply with certain other obligations in the grant agreement, such as, if the grantee has not fully complied with the grant purposes, or if you need to protect the use of the grant funds in any way. This allows you that flexibility. So again, if you are the grantee, this provision requires a level of scrutiny, because you want to make sure that you're not being withheld from the payment under the grant agreement just for any reason whatsoever. You want to be careful to limit the grantor's discretion in terms of when they want to discontinue or modify or withhold any payments or require repayment. Okay, so you want to make sure that it's in very specific circumstances. Okay, if you are the grantee, for example, you may only agree to repay funds if there's fraud, or if you use them in completely non-charitable ways. Excuse me. So this is one that requires a level of scrutiny. Again, it's really only required in expenditure responsibility. So if this is not an expenditure responsibility grant, as the grantee, this is something you want to push back on. Okay, publicity and acknowledgement. This is one that we see a lot, especially in grant agreements where one of the parties is kind of a big name. High-profile clients, high-profile charitable organizations, publicity acknowledgement provisions can get really complex. So first, as both parties, you want to take a look inside, do we want the grant or the grant purposes to be confidential for any reason? In some cases, the grantor might want to support an organization or support a project, but doesn't want it to be made public that they're supporting this project or this organization, okay? In that circumstance, you may want this publicity acknowledgement provision to state that, unless required by law, that the grant and the grant agreement will remain confidential. Either party or both parties may want to pre-approve any public, press releases, any publications, or any kind of reporting regarding the grant or the grant purposes. So you want to make sure that if one party or both wants kind of prior approval, that is in the publicity and acknowledgement provision. And what does that look like? Does that mean, you have 5 days, and if we don't hear your approval within 5 days, it's automatically approved or it's automatically disapproved? All of that can come into play, because you'll definitely have circumstances where one organization wants to approve something or wants to review it before it's published, and then, you send it to them and they go dark. So what happens then? Does that mean it's a green light, or does that mean you can't publish it because they haven't approved it at all? Okay, and so you really have a wide scale here, anywhere from confidential to kind of co-branded activities and projects. And when we're talking about co-branded activities or projects, it may be something where the grantor and the grantee get equal publicity with respect to the grant purposes or the projects being funded with the grant fund. One thing you want to be careful of as the grantee is to avoid any version of recognition of the grantor that could be seen as advertising. You always want to make sure that any kind of publicity or acknowledgement that the grantee is providing to the grantor falls squarely within use or acknowledgement, and it doesn't run afoul of kind of advertising or impermissible benefit to the grantor. You don't want to use language kind of promoting the grantor. You want to use language more specifically to factually describe the grantor's support of the project or of the grantee, or acknowledge them as a supporter of the project and of the grantee without promoting them or providing advertising for them. The next provision is intellectual property. And this provision, again, is one that comes into play in our more comprehensive grant agreements. You won't typically see it in, plain vanilla grant agreements where there's no IP being developed. In general, so for intellectual property, you want to make sure that you're covering all of your bases. If there's going to be research, for example, that the grantee is providing or conducting with the grant fund, who owns the IP? Who owns that research once it's being developed using the grant fund? In general, what we'll see is the grantor will provide the funding, the grantee will conduct the research or create the developed project, and the grantee will be the one who owns that project. And then in return, the grantee will provide the grantor with a license to use or promote or publish any of the developed IP, whether that's research or anything else. If you're the grantor, you want to make sure you have a solid perpetual license, especially if you're not going to own the IP at all. You want to make sure that you have a solid license to be able to use the developed project or IP in the future. So that includes publishing derivatives of it, using it for your own research or for your own charitable purposes if you are a charitable grantor. And if you're the grantee, you want to make sure that the license is limited to any non-commercial tax-exempt purposes. This means you want to make sure that the grantor, while they have a license, may be perpetual, maybe royalty-free, that it's limited specifically to their own non-commercial purposes. So the grantor can't then go out and sell the research that you conducted using charitable funds. Now, in terms of thinking about your intellectual property provisions, know that it may also impact the future use of co-branded programs or materials. If you have a project or a program that is co-branded between the grantor and the grantee, meaning it's publicized as as something that they're doing together, kind of more in a partnership, any kind of co-branded material, you want to make sure who owns that U.S. license, because it can impact the future use of those of any of that IP. So, for example, you have a grantor who is funding a particular project, and this project is now co-branded, and they have naming rights, they have a license to it. If the grantor stops funding this project, the grantee wants to be sure they can continue to use any of the developed IP or developed research that came along through that grant. Okay, so the intellectual property provision can get very detailed depending on what kind of project or what kind of research is being funded with the grant. Okay, next we have record keeping and reporting. Again, there is a level of minimal reporting that's required for expenditure responsibility. At minimum, if you are a grantor and you're exercising expenditure responsibility, you need to collect at least annual reports regarding how the grant funds are being used. Okay, anything more frequent than annual is just providing increased oversight for the grantor, and both parties need to decide what level of oversight makes sense for the grant. Too much oversight can be unduly burdensome for the grantee because you're spending a lot of time kind of writing these reports and reporting back to the grantor as opposed to actually doing the work on the ground or achieving the purposes for which the grant was funded. But if it's too infrequent or they're not detailed enough, then the grantor itself may not be able to comply with its expenditure responsibility requirements for the IRS. So you want to make sure that the record keeping and reporting provision is detailed enough to provide the grantor with the information that it needs, and that the grantor has the right to kind of examine the books of the grantee, but you want to limit it so that the grantor doesn't have, just free reign, and they can't come in whenever they want. They have to give the grantee reasonable notice. So this is a back and forth and kind of a balancing act to make sure that the grantor has sufficient oversight, but that it's not too burdensome for the grantee and the grantee is able to comply. And in general, we like to include, when we're doing grant agreements like this that require some level of reporting, provide an example of what the report would look like. So we would generally attach an exhibit that would be a sample report so that the grantee knows exactly what information they need to provide, and that both parties can agree on that up front, and they know the form that it's going to take. If you're the grantor, one thing we'd like to also include is the right to request additional reports. The grant agreement itself might say you only have to do one final report within a year after the grant is made, because that's what's required for expenditure responsibility. But if for whatever reason the funds are not fully expended at the time the final report is made, the grantor wants to retain the right to request additional reports so that they can monitor the expenditure of all of the grant funds. If I'm going a little faster, Bob or Darius, if you have anything you want to add, feel free to jump in. Okay.
Yeah,
Next,
let me jump in for 1 second. Just for those of you who are looking for or seeking CLE credit, just a reminder, the code word for CLE credit is agreements with an S 2023. We'll report that again at the end, but that is the code. Nikki, if you could go on for a few more minutes and then we'll get to Darius.
Great. All right, good. We're coming towards the end of these. I'll kind of breeze through these a little bit just so we can make sure we wrap up in time. Next, compliance with law. This is a provision we like to include specifically when we're talking about international grant making. And this can be very broad. So basically, it's a provision, kind of a catch-all, that ensures the grantee complies with all applicable laws. And so that's a really broad statement. And it includes, for example, the U.S. Patriot Act and any other kind of anti-terrorism, anti-money laundering laws that apply when making international grants. If you are a grantee and you're a domestic charity, you want to strike this, okay? Because it may be too burdensome, it may result in some inadvertent violation. Not saying that you would be involved in, terrorism or money laundering, but the broad catch-all is all applicable laws and regulations. And so you may inadvertently run afoul of a registration requirement with a state or a particular law regarding charitable solicitation in your state. And so that could trigger an inadvertent violation of the agreement, which then may trigger a repayment of some funds of the grant agreement, depending on what other provisions of the grant agreement say. So if you are a domestic charity and this is not an international grant, the grantee would likely want to push back on this provision. But if you are a grantor, you want to keep it in because it covers you in terms of international grant making. Again, this is representations and warranties. This is a similar catch-all. As the grantor, you want to pack it with anything you want the grantee to rep and warrant to. For example, you want them to ensure that they are a 501c3 organization qualified to receive charitable contributions. You might want to, depending on what the grant purpose is, you want to have them rep and warrant to compliance with fundraising and charitable registration laws may be important to you. You want to make sure that they haven't run afoul of any other laws in terms of, whatever it may be. Depending on, certain laws require certain registration for certain types of projects in their state. It can be kind of as fulsome or as narrow as you want as the grantor. As the grantee, you want to take a very close look at any reps and warranties to make sure that you're able to comply with them and that they're accurate and they're not unduly burdensome and that they are tailored specifically to the grant purposes for which the grant is being made. So this is really another catch-all. It can be overly broad. Overly broad or stringent warranties can be burdensome. And again, much like the compliance with law provision, can result in inadvertent violation of the agreement. So you want to be very careful here. An indemnification provision. This, in general, tends to be one-sided when they're in grant agreements. They're basically having the grantee indemnify the grantor, depending on how much risk is involved in the grant purposes. It protects the grantor against the grantee's negligence, any breach of the agreement, any infringement of IP rights. And so as the grantee, you need to think about is there any reason why the grantor should also be assuming some risk associated with the grant purposes? Depending on what the purposes being funded are and how specific they are and how involved the grantor is, they maybe should be assuming some of the risk. And so we may want to make this mutual. But in general, you'll see them one-sided where it's the grantee indemnifying the grantor. Okay, so termination provision. Again, so generally we see them one-sided where the grantor has the right to terminate. But again, we want to consider, is there a position or is there a circumstance in which the grantee may want the right to terminate the agreement, okay? Also, the grantee may want to limit the termination rights of the grantor and make it for cause only. So the grantor can't just decide one day they no longer want to fulfill the grant and they're just canceling it. They have to terminate for cause only. And cause can be for the grantee failing to adhere to the grant agreement and fails to cure. It can be for misusing the funds, but we want to make sure we limit it if we're the grantee. And also pay attention to the termination rights because termination may trigger a repayment of any unexpended funds as of the date of termination. And relationship with the parties, this really just kind of protects the grantee if the grantor is a non-charitable organization. So if you're the grantee and you're a charity and the grantor is a non-charitable organization making a grant to you, this really just lays out that this is not a partnership, this is not a joint venture, this is just a grantor-grantee relationship, and that no party has the authority to obligate or bind the other party. So just is kind of clearly defining the relationship and making sure everyone is aware of what's going on here. Governing law, this is pretty straightforward. In general, this limits the available jurisdictions where you can address disputes. Typically, we see the governing law be the state in which the grantee is located or the state in which the project is occurring. So the activities that are being funded, wherever that is happening, if we want that state to be the governing law of the jurisdiction. In most cases, that's fine, but sometimes the grantor will push back and want it to be their state, even though nothing's happening there. So we want to, between the two parties, figure out what's the burden if either party is required to defend in the given state. And no assignment or modifications, again, pretty straightforward. We want to make sure that if you're the grantor, that the grantee cannot just assign their rights out to another party or their responsibilities, and that, this is also a catch-all to make sure that you are including everything in the agreement, that the agreement will supersede any kind of written or other oral agreements or understandings between the parties. So for example, if you're agreeing to pay the money, pay the grant 30 days, but you have a grace period, make sure that grace period is not just an oral understanding between the parties. If everything is in writing, in the grant agreement, signed and sealed. And that is it for my section, and we're going to move on to Darius.
Darius, we've got lots of questions coming in at the end. We'll try to get to as many as we can, but Darius, it's all yours.
Yeah, thank you. And thanks again for the opportunity to be here. I love seeing the questions. These are excellent questions. So I'll be brief so we can get to as many of them as possible. But again, I'm Darius Graham. I'm with the Harry and Jeanette Weinberg Foundation. I'm a program director, so I'm one of the folks that has the great pleasure of working with nonprofits, our grantees in particular, to walk them through the process of applying for, potentially receiving, getting the grant agreement signed, and then reporting back to us on all the great work that they've done. So just a little bit about the Weinberg Foundation. We provide grants to 501c3 organizations only that provide direct services to low-income individuals in our priority communities, one of which is Baltimore, where I'm located here today. We provide grants of 3 different types. So those can be program grants or restricted grants, operating grants or really unrestricted grants. And then we also do capital grants, and those are for the acquisition of a building or renovation of a facility. That can also be for technology as well. And so each of those has different types of requirements and a little bit different kind of agreement as well. And I'll get into some of those provisions briefly. One of the first things I just wanted to mention, this was mentioned earlier, but we have this saying at foundations that if you've seen one foundation, you've seen just one foundation, because we all do things a little bit differently sometimes. We have different funding priorities, different timelines, processes. And so the grant agreements will likely be very different and vary from foundation to foundation. So I'm just giving you some examples of if you were to apply for and receive a grant from the Weinberg Foundation, what you might expect to receive from us, and then also what you may encounter with some other foundations as well. So with Weinberg Foundation, once you've made it through the application, review, and approval process, and you get that wonderful email or phone call letting you know that your organization is receiving a grant, you would then get a grant agreement, which has many of the kinds of provisions that Nikki just walked us through. Other foundations that I know of do not do a separate full grant agreement. Some of them will just do a letter, and that letter will be an award notification with some of the provisions in there, and then you countersign that and send it back. But typically for us at Weinberg Foundation, you're going to get an email or a phone call plus an award letter, and then you're going to get a separate full agreement. For some smaller grants, depending on the size of the foundation, if you're getting what's considered a small grant for them, you may just get that letter. So there are some rare cases where we do just send a short letter and saying by, accepting this check, you agree to not, do X, Y, and Z. But typically you'll get the full contract from us. So one of the other things I wanted to mention is that these contracts are created in consultation with our foundation's council. So although we will sometimes get requests to change certain provisions or to make different provisions within them, unfortunately, we typically can't do a lot of changes to them. What we do is we'll have the standard agreement, which has all of the things that Nikki talked about. And then we will have an Exhibit A, which the heading is project details. And so that's really what we make unique for each grant. So on the project details page, that will just describe what the grant is going to support. So I saw the question about, what's the difference between restricted or unrestricted, or what's too narrow. On that project details page, we're going to put, if it's an operating grant, we're just going to generally put what the mission of your organization is. So if it's to provide healthy and nutritious food to communities in Baltimore, we're just going to put that as the grant purpose. And then you can use the funds for your organizations as appropriate. If we're funding a specific program, then we're going to be a little bit more specific on that project details page and say this is to provide healthy and nutritious food at these 4 schools in Baltimore City. So it can be specific or it cannot be, depending on the purpose of the grant. Nikki touched on publicity, and I did want to talk about that as well. We have a similar provision where we are pretty straightforward about what we require, which is at least 2 weeks notice to review requests to include our foundation's name in publicity. We generally take the approach that, you as the nonprofit or the grantee, you're the one out there that's doing the great work in the community. So we want you to get all the credit for the work that's happening. So if you want to list us somewhere in a press release or on a website, that may be okay. We just want to have our communications team look at it, but we really don't want to be the headline or be prominent. We want you to get all the credit for the great work that you're doing. A counterpoint to that, however, is that for our foundation with our capital grants, if we are providing a grant of a certain amount or higher to help you purchase or renovate a building, the grant agreement will likely have a naming requirement in there. So you would need to, before you get the actual contract, we would have had a discussion about sort of what part of the building you're going to name or where the name is going to go. Our communications team would have vetted that as well, but that naming provision will be there as well. We're also pretty focused on, with these capital projects and the buildings in particular, we want to make sure that if we're providing a capital grant to help you purchase or renovate a building, for example, that, a year after we provide, a $2 million grant for you to go into this great building, that you're not going to just transfer the building or decide to move to a different location, we want to make sure that your organization is going to get the use out of that facility. So we will have some provisions about what might happen should you want to transfer that property, which would likely require some written approval by the foundation's board. So that's something to be aware of for the capital grants. Nikki touched on governing law. That's something that we get questions about quite often. We are headquartered in Maryland, so all of our contracts, to my knowledge, will include Maryland as the place for that. We fund in other states, Illinois, California, Pennsylvania, New York, Chicago, and Hawaii. So among those states, sometimes we get requests, can we change it to our state? And unfortunately, again, we're headquartered in Maryland, and being a standard contract, we typically have to leave it there in Maryland. There were some questions about reporting, and I did want to touch on that as well. We often get questions about sort of what types of report can satisfy the reporting requirements in the contract. Typically, if we provide a grant for 1 year, we're going to require a grant report at the end of that year. We usually are not very too specific or prescriptive about what that report looks like or how it's formatted. We will have an Exhibit A or Exhibit B that says this is the kinds of things you can include in that report. Sometimes we will get an organization's annual report, a standard report they provide to the community, plus a cover letter speaking to what they've done with our grant funds. So it really varies. For a 2-year grant, we're going to require a grant report at the end of the first year. Once we get that grant report, then that's going to trigger the second year's payment. And then at the end of the second year, we'll require a grant report as well. So for those multi-year grants or multi-payment grants, we do, really will require the report before we're able to make that additional payment. And even on those capital projects, there may be even more specific things, like we may want to see certain specific progress with the capital project. If it's a large multi-phase building and we're giving you a 2-year grant, we may say, at end of 1 year, and that first year payment, we want to see that phase 1 has been completed, that such and such has been done, and then we can release the second payment. So just be aware of that. The final thing that I will say, actually 2 more things. One is there was a question about service contracts versus grant agreements. I will say that for us, we do the grant agreements when we are providing grants to the 501c3 nonprofits. If, however, we're working with a consultant, someone that's helping us create a new strategy or conduct an evaluation of a program, that's something that's handled separately as a separate kind of contract. So some of this would be quite different, but the grant agreement is typically just for our grants. The final thing that I would note that, when you get these grants, you'll see all the provisions that are in there. I always encourage grantees when in working with foundations to, ask for what it is that you need or what you hope for, but understand that there may not be as much flexibility as you may want. So if you see a provision and you say, this foundation is giving me a very specific template of the report that they want, and you want to ask, can I submit a different kind of report? You can certainly ask that, but know that the response that you will get may vary depending on the foundation. Also understand, how changes can be made to things like reporting dates, for example. You may get a 1-year grant, have a deadline that's like at the end of the year, it's the holidays, there may be a lot going on. So understand in advance how you can go about changing the reporting date if you need to, and if that has any other consequences for the grant. Again, some foundations may be more flexible than others. Typically with Weinberg, when we get requests that says we need a couple more months to spend the grant funds, or we just were able to hire, it took us an extra 6 months to hire the person that was going to do the work that the grant is for. And so we try to be flexible with those. So just be in touch with your foundation and understand what the requirements are for getting things changed. So I will leave it at that for now. I hope that was helpful in giving some examples and eager to answer more questions.
So we've got lots of questions and we'll try to get through as many as we can. If we don't get to all of them, we'll try to respond individually to people. We have the ability to we know where they came, with the email address they came from, and we'll try to respond if we don't get to them. Let me remind you, first of all, one more time, for those of you who are applying for CLE credit, this webinar is eligible for CLE credit. So the code word is agreements with an S 2023. So I think we're giving instructions on how to apply for CLE credit. But again, you'll need that code word. So let me, I'm going to try and go through, at least in the time we have, some of the questions we got. And Nikki, Darius, please jump in as appropriate. Nikki, let me start with you on maybe the first question, which somebody asked, whether we could give an example of a purpose clause that's too narrow. You had mentioned, and maybe you could, if you could think of one or have some thoughts on that, that would be great.
Yeah, I saw that question. I think in terms of a purpose clause that's too narrow, it really depends on the recipient organization and the amount of the grant. So one example, I guess, that comes to mind is if you are a charitable organization and you are hosting, doing some research, and the grant purposes, it's a $50,000 grant, and the grant purposes are limited to hiring an editor for the research. $50,000 may be too much money just for an editor for the research, depending on what the research is. And so that may be too narrow of a purpose for that grant amount in that situation, which may require you ultimately to end up returning some of the unexpended grant amount.
Second question someone posed was, if the donor is not pressing for a formal grant agreement, is there any reason why the donee should raise the question? And why would the charity want the obligations to be in a grant agreement? And the answer is, if you're a grantee, it protects you too. In other words, let's say the donor comes to you and says, hey, you didn't use my money properly, or I told you had to use it within a certain period of time. You, the donee, might want to say, well, wait a minute, the grant agreement didn't provide for that, or you never told me that, or here's what the grant agreements, here's what our agreement said. So it can protect the grantee also against a claim from the grantor that you didn't use the money appropriately. Darius, I'm wondering, just from your experience as a grantor, have you ever had that situation where a grantee didn't use the money appropriately, or have you ever found yourself at odds with a grantee where you were in that situation where somebody didn't do what you thought they were going to do?
Yeah, I'll give two answers to that. One is on the question that we received. I think, if the reporting requirement is not spelled out in the agreement, sure, that may be great for you as the organization because you're not given a strict template to follow or what you should turn in. But I think just from a donor sort of cultivation, sort of keeping a good relationship with the funder and hopefully possibly getting a renewal, certainly ask, how can we let you know about, what we did, or what's a good way to report back, even if informal, even if verbal. I think, Bob, to your question about an example, the one that's coming to mind, which is a sort of different topic, but comes around with fiscal sponsorship. And with those, we have specific purposes of like where the dollars are going to the ultimate recipient. And there are times where we've had to really sort of double and triple check and ask for more information to make sure that our grant dollars are getting to the ultimate intended recipient.
Let me ask you, somebody asked this question, Darius, let me ask you this one. Somebody asked the question, how often do you pick up the telephone and call the grantee? Did you ever do that, or is that just something that's not done?
Are you saying, was that question about for like the contract or just generally just to check in?
Somebody asked the question of, I'm trying to find the specific question. It was somebody asked the question, I guess, it says, how often do you end up doing phone calls to congratulate the awardees? Oh,
it depends. I think it happens frequently. it's just the nature of scheduling when we might get approvals, when we internally get the approval notifications from our board. I think in some cases we prefer to make the calls, but sometimes if we're not able to do that, or we call and leave a voicemail, but we typically try to do it. I mean, for me, I love doing it because it's fun for me to actually have the conversation and to deliver the good news. So we do it sometimes.
I can tell you, as I also sit as a director of the Venable Foundation, we have our own foundation at Venable. We really don't. We very rarely actually call the grantee just because of the volume of it's just hard to find the time, to be perfectly candid. So it's something we probably should do more of. We probably don't do that much of. Nikki, let me ask you, there have been a lot of questions posed on international grant making, which is a subject in and of itself, and maybe it's something we'll do a separate webinar on, but maybe could you take a minute or two and just talk a little bit about expenditure responsibility, where does it come from, when does it come into play, just maybe in broad strokes what's involved with it.
Yeah, so I'll try to hit a number of questions about expenditure responsibility and international grants. So I'll try to hit all of them in my answer. So I think, yes, in general, you'll need a grant agreement whenever a charity or whatever the recipient organization is not a domestic U.S. charity. Okay, so whatever that may be, anytime the recipient is not a domestic U.S. charity, you need a grant agreement and you need to exercise expenditure responsibility. The provisions for expenditure responsibility can be found in the Internal Revenue Code, section 4945H, and that lays out all of the requirements. So you want all of the provisions we talked about that are included in expenditure responsibility, and for international grants specifically, you also want to include the language that we had in our compliance with law provision, basically having the grantee agree to comply with all applicable law and regulations, including all U.S. laws relating to anti-money laundering, anti-terrorism, and all of that. You also want to check the OFAC list for the specially designated individuals to make sure that the organization that you're providing funds to, or the country in which you're providing, the organization is in which you're providing funds, is not on essentially, the SDN list, basically prohibiting, U.S. organizations from funneling money there. And in general, that list includes countries where there are sanctions being issued against them, or individuals that have sanctions against them by the U.S. government, and you'll be prohibited from providing funds to them. There was one question, I believe, about currency exchange. So in general, we don't include information on currency exchange rates in the international grant agreement, but you do want to include, which is why it's important to include the specific currency that the grant is going to be made in. So for example, if we're going to make a grant in US dollars to a foreign grantee, then me as the grantor, I'm going to give you, 50,000 US dollars, and whatever that ends up being once it's been exchanged by you is, what you end up with. And I don't have any obligation to kind of true that up or cover any losses based on the exchange rate. Similarly, if I'm a US grantor and I'm making a grant to an international organization and I'm making it in, euros, right? So whatever your local currency is, I'm going to make it in that local currency. And if for whatever reason, once it hits your account, it's less than what it was intended based on the US, the currency of the grant agreement, it is my job to true that up so that the amount you receive is the amount specified in the grant agreement. So that's why it's important to state the currency being used in the grant agreement itself.
There is a.
I think that. I think that covered all of the expenditure responsibility international grant questions.
Darius, let me ask you a question on some questions on reporting requirements, and some questions about what do you do if the grantor doesn't you miss one and the grantor doesn't come to you and say, hey, you missed it, and is it good enough if the reporting is verbal rather than in writing, or do you require that it be in writing?
That's a good question. So we would want to have the reporting in writing. There are some funders, really probably a small number, that would take sort of a verbal report where they may take notes or just have a phone call and that satisfy for the report. But for us, we would want it written because there's generally two components that we would ask for. One would be financial. So we would want to see like your organization budget for that period, like the actuals. We want an audit as well, most recent audit. So we'd want the financial piece, and then we'd also want the narrative. So that would be where you would write about, we asked for a grant of $50,000 to provide food in these neighborhoods. Here's what we did. Here were the challenges, and so on. So we would need that to be written, but you would have a lot of flexibility in terms of the formatting, the template, the length, and so on.
There's a series of questions about flexibility, level of flexibility in a grant agreement that a grantor will permit. Now, in my experience, what I found is many grantors will say, there's no flexibility. You've got a grant. We want to have the same grant agreement with all our grantees. And if we start modifying with you, or we change this, we change the indemnification with you, we can't be in a position where we have different provisions for every donee, that it's just too hard for us. Others will say it's all a negotiation. I'm wondering, from your experience, how does Weinberg approach that? That will you permit it to be a negotiation, or is it sort of, no, this is it, you take it or leave it?
Well, I think maybe a mix in a sense. I mean, we definitely don't want to have different, like radically different agreements for all of the mini grants that we do, because we do many. But if you have particular concerns about a provision, it's something that we would certainly want to have a conversation with and understand what scenario you're thinking of. With publicity, for example, is it that you're going to end up having some like rapid publicity and you're not going to be able to meet the 2-week requirement, and we can sort of like make a plan for that? So I think it's we don't want to have different agreements for all, but we're open to sort of like understanding what your concerns are and trying to work something out with you. The Exhibit A, or the project details, is where we can be a little more flexible, because that is different for every grant. That's where we talk about the purpose of it, the length of time, the address if it's a building, the reporting requirements. So we can be most flexible on the reporting requirements, what's in the report. But for some of the things, like all the things Nikki went through, we really unfortunately can't really make any big changes to those.
So we're at the end of our time, and I want to thank Nikki and Darius for joining us today. We thank all of you for attending. It really is a record number of participants. We try to do these webinars monthly, and keep an eye out for notices of next month and future Venable nonprofit webinars. We love doing these. It's a lot of fun, and we appreciate everybody participating. Again, if we didn't get to your question, we'll try to respond individually, or I think you've got our email addresses. You can always ping us, and we'll try and get back to you all. So we hope you've enjoyed it. Again, for those of you who are registering for CLE, the code word is agreements with an S 2023. I hope you've enjoyed this time today. Thank you again, and keep an eye open for future programs. And with that, we'll sign off and hope you all have a great day and a great week. And again, Happy New Year to all of you. So take care.